Hello everyone, I'm Dr. Kalpana. Today we are going to learn about liquidation of a corporate person, as we have already discussed about corporate insolvency resolution process, where a resolution plan is prepared by corporate insolvency professionals, and in case it fails or resolution has not been provided in a time bound manner, then liquidation is the only option remains with uh, creditors to get back their debt and other stakeholders. So let's begin. What is the meaning of liquidation? Liquidation refers to a process by which a corporate person's assets are realized and distributed to the creditors when revival is not possible. So under corporate insolvency resolution, if you remember, there are two kinds of creditors: financial creditors who have given the loan, and operational creditors who are providing services, goods, and other materials on credit basis. So they are also called creditors, but they are called operational creditor because they are facilitating operations. Governing law is part 2, chapter 3rd of Insolvency and Bankruptcy Code 2016. And the purpose is ensuring equitable distribution of assets and final dissolution of the company, so that as the uh, creditor's right is supreme in law. So, following that principle under this code, finally, in case corporate insolvency resolution plan fails, then liquidation remains the only option to give back the debt of the creditors. How does it initiate? Section 33 of Insolvency Bankruptcy Code provides liquidation can be initiated under these circumstances. First thing, no resolution plan is received or approved by corporate insolvency resolution professional. The period time is 180 to 90 days. 90 days is an extension which can be given under this code. Resolution plan is rejected by adjudicating authority, and committee of creditors with 66% vote decides to liquidate. That is also power given to committee of creditors, which is composed by financial creditors and operational creditors. Contravention of approved resolution plan by corporate debtor. In case of there is a contravention found at the part of corporate debtor, then also liquidation can happen. So there are four circumstances where liquidation process can be initiated under section 33 of IBC. Adjudicating authority is National Company Law Tribunal. In short, we can call it NCLT, issues a liquidation order. So, what is the process? How does it happen? So, appointment of liquidator, usually a resolution professional is there, which is ordered by NCLT, issues public announcement for the claims and orders moratorium on legal proceedings. Role and duties of liquidator is very important, which has been provided under section 34 to 36 of Insolvency Bankruptcy Code. Acts as officer of the court, means it's a quasi judicial sort of function, takes custody of all assets and records. That is the first requirement for liquidation in order to know what assets are there with the corporate person, forms the liquidation estate, evaluates and admits claims of creditors, and next sells assets via auction or private sale, though default is auction because the better prices are possible while auction is announced or done, distributes proceeds according to the waterfall mechanism. So liquidation estate of estate is provided under section 36. It includes all tangible, intangible assets owned or possessed by corporate debtor. What is excluded under that liquidation estate? Excluded assets are personal assets of promoters not guaranteed to the company, trust assets, etc. Claims and stakeholders. These provisions are provided under section 33, 38 to 42. Claims submitted within 30 days of liquidation commencement date. Stakeholders, secured creditors, operational creditors, employees, government, and others. These are the stakeholders which are identified under insolvency bankruptcy code when it comes to distribution of certain amount after liquidation is concerned. So first is secured creditors, and second comes operational creditor. If anything is left, then employees, government, and others, wherever dues are there on the part of corporate debtor. Liquidator verifies and may accept or reject claims. It's not necessary. Whatever a person is making claim, it can be accepted. It can be rejected also on the merit base, whether it is maintainable or not. Depending upon the fact sheet and claim is maintainable or not, it's entirely the understanding and discretion of the corporate insolvency professional. Appeal mechanism. Creditors can appeal the liquidator's decision to NCLT. In case liquidator rejects the claim, the person who is an aggrieved party can appeal to National Company Law Tribunal. What are the modes of sale when liquidation initiates? So default mode is definitely auction. You must be knowing and seeing a lot of auction uh, messages or sales are notified in newspapers every day. So that is a very, very common method. So we call it a default mode. Private sale permitted under certain conditions in case auction doesn't give very, though if auction is executed, then there is no need of private sale. Going concern, sale permitted in some cases, and proceed to go to into liquidation bank account. So these are the mode of sale, though most of the common mode of sale is auction. Waterfall mechanism of distribution. What is that? That is provided under section 53. Insolvency resolution process cost and liquidation cost. So secured creditor, unsatisfied debt, and workers' dues are 24-month is a timeline. They should be paid. Employees' dues are 12 months. Unsecured debtors comes under fourth. Government dues and remaining secured debtors if unpaid. Other debts and dues. Preference shareholders, equity shareholders, or partners. So secured creditors may relinquish or enforce their security outside liquidation under section 52. Dissolution of corporate person is provided under section 54. Dissolution means company would no more be in existence. So after asset distribution and report submission, liquidator applies to National Company Law Tribunal for dissolution. NCLT passes dissolution order, copy sent to registrar of company, corporate entity ceases to exist. So that is the legal implication and consequence of liquidation process when it is completed. So company would no more be in existence after liquidation process. There is one option which is provided to corporate debtor that has provided under section 59 of Insolvency Bankruptcy Code. Voluntary liquidation initiated by solvent companies requires board and shareholders resolution and declaration of solvency and appointment of liquidator, reporting, and final accounts. So that process can be followed by voluntary liquidation, which has been provided under section 59 of this code. There are some important cases which I have briefed here in very short, because examination season is going on. So you may not be take up much load. So Swiss Ribbons versus Union of India, which where constitutionality of this code was challenged, and it was upheld by the Supreme Court of India. State Bank of India versus Ramakrishnan 2018 case, moratorium does not apply to personal guarantors during liquidation. That was the contention made in this case. ArcelorMittal case 2018, again, these are not so old case, clarified eligibility and timelines under IBC. So you can refer while answering your questions in your examination. What are the challenges when liquidation initiated? Delay in realization and distribution, that is very much inevitable and possible. Valuation inconsistencies, that is the most difficult part of liquidation when it comes to valuation is concerned. Need for digital and transparent auction mechanism, which is again a challenge, and strengthening NCLT infrastructure. So these are the that would keep on something posing whenever it comes to enforcement of any code is concerned. That would always be there in some nature or other nature. So concluding today's lecture, liquidation is the last resort in insolvency process. It ensures that stakeholders receive at least partial repayment, that inefficient companies are removed from the economic ecosystem. That is the purpose of liquidation, and uh, making those company to exist to cease. So insolvency bankruptcy code has brought significant improvements, but challenges remain in implementation for sure. With this, I would end here. Thank you so much. Have a great day. Take care. Happy learning.